Family matters encompasses everything from maternity leave to part-time working to flexible working, and if you get it wrong, you can have claims going from unfair dismissal to sex discrimination to breach of contract. So there are quite severe implications. It's a very, very large topic, and so all I'm going to do today is skate through some of the main issues, and I'm going to talk very briefly about what family rights are, and then I'm going to talk about some case law, family law, where it goes wrong, what happens when it gets to court. Caree is going to deal with some case studies on flexible working, and then Caree's also going to deal with some tips for getting it right. At work, what happens when a woman is not only pregnant, but where you have women of childbearing age at work? It's not just pregnant employees, it's women of childbearing age. Firstly, dealing with obviously pregnant employees, all employees have the right to time off for antenatal care, and it is paid. You have to give the employee reasonable time off to attend antenatal appointments, and they get their normal wage for that time off. It may sound a silly question, but what is antenatal care? What does it encompass? Any ideas?
Midwife appointments.
Midwife appointments.
Scans.
Scans. Is a scan antenatal care? That is a question that is asked. I personally think it is, and I think employers would be silly to not to give time off for a scan. But things like relaxation classes. Now, many employers will say, well, that's not really antenatal care. Antenatal care is about care of the baby rather than. But relaxation classes would be classed as antenatal care. Funny enough, there is a query as to whether or not scans are part of antenatal care. In my view, it is, and I think most employers would be on dangerous territory if they tried to say that antenatal care involving scans wasn't permitted. What about fathers-to-be or partners? No time off for them. They are not entitled to paid time off to attend an antenatal appointment, even if it's a scan. Obviously, it's quite common now for fathers-to-be to attend scans. No right to paid time off for fathers. That may change. That's one of the kind of paternity provisions which may change. Most employers will allow employees maybe unpaid time off, potentially to take holidays. Some will obviously allow paid time off, but there's no legal right to paid time off with being fathers. Can you refuse time off? Well, potentially yes. I mean, how many appointments are reasonable? How many? What is reasonable antenatal care? The government's figures say that on average, most women will have 10 antenatal appointments during the course of their pregnancy, which is obviously one a month. Often women will have quite a lot more. Some employers will try and put a cap on the limits of antenatal care, saying that it's not reasonable. And the test is that not that all women have to have the time, are entitled to the time off, but it's a fact that they can have reasonable time off, and you can't unreasonably refuse the time off. There's a lot in the notes on this. As I say, we're having to skim over. There's an awful lot of issues in paternity rights. Have a read of the notes, and if you've got any concerns, queries, get in contact with us. Health and safety risk assessment is the second main area covering not just pregnant employees, but if you've got a workplace where you have women of childbearing age and your workplace is one which is potentially risky. If there's hazards includes chemicals, working with chemicals, working with biological agents, but it can also cover, according to the Health and Safety at Work Act guidance, matters such as posture. So if you have people working in cramped conditions, or maybe sitting at a desk all day potentially is a posture issue. Fatigue is an issue, so for example, night workers, if you have workers working shift work or working overnight or working late evenings or very early mornings, those are particular issues where, if you have women of childbearing age, these are the kind of issues you should be factoring into a health and safety assessment that you carry out. Movement, if you've got workers doing repetitive jobs on a line, for example, those are areas where, if there is a risk to the pregnant woman or to her child, is an issue which should be factored into any health and safety assessment. So all employers are obviously obliged to carry out health and safety assessments. If you've got women of childbearing age in the workplace, you should be factoring in issues specifically. Even if you haven't got pregnant employees or employees you aren't aware are pregnant, you should be factoring in these kind of issues into health and safety. If there is a risk to the health of a pregnant employee, and that cannot be ameliorated within the job, if you can't remove the risk, women have a right to be offered an alternative role in the workplace. Now, the alternative role should be a reasonable alternative role. It should be, if possible, on the similar terms and conditions, and so it shouldn't be disadvantaging the pregnant woman in any way. If there isn't an alternative role, and the risk can't be ameliorated, you have to suspend, and you'll be suspending the employee on full pay. Question as to what full pay is. Full pay is, does it include bonuses? Does it include shift allowances? Does it include productivity bonuses? Does it include performance-related bonuses? There's a case involving cabin crew. In fact, there have been several cases across Europe involving cabin crew where air staff are mandatorily grounded after, I think, 19 weeks of pregnancy. And there's a question there about, well, do they get their shift allowances? Do they get their unsocial working conditions allowances? It's still actually slightly open, which is why I haven't put this case in. But there are certain, and if you're in the situation where you have employees who can't, who have to suspend for these reasons, get in touch with, and there is an issue about bonuses, etc., get in touch. Some antisocial elements of bonuses, for example, you are only getting it because it involves overnight stay, probably they aren't payable. But other bonuses, for example, performance-related, they probably are. What do you need to do if there is well, in some cases you have to perform a specific risk assessment, and in other words, when you have noticed that a woman is pregnant or giving birth or is breastfeeding, you are required in certain circumstances to carry out a specific risk assessment. And that is, if you have written notice of pregnant, birth or breastfeeding, the work must give rise to a risk to the mother or the baby, and the risk must arise from working conditions, for example, working nights, or work processes. That could be the nature of shift work, the way that you undertake the work, or exposure to physical or chemical agents. So in those circumstances, if you work for an employer where there are those kind of processes going on, or people are handling hazardous materials, or working on a line with repetitive processes which could potentially give risk, you must carry out a specific health assessment in relation to that employee.